All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good afternoon and welcome to the Court of Appeals. Your panel this afternoon consists of, to my right, Judge Valerie Zachary, to my left, Judge Hunter Murphy. I am John Tyson. We have one case on the docket this afternoon for argument. I'd like to introduce our clerk, Mr. Gene Soar, who opened court, and our court marshal is Mr. Richard Rebelliard, who is here too. Are there any preliminary matters to come before the court before we get started?
No, Your Honor.
Okay, so without further ado, we will hear from the appellant, Mr. Costanza. Good afternoon.
Thank you. Good afternoon. And may it please the court, my name is Rich Costanza. I represent the appellant, Mr. Mahatha. I would like to reserve 5 minutes of my time for rebuttal.
Okay, Mr. Soar will have that noted.
All right, thank you, Your Honor. In 2004, the General Assembly made a decision that having complete open file discovery in a criminal case was a fundamental, basic tool for a criminal defendant to receive a fair trial. And the discovery obligation falls not only on the prosecution, but it falls on the police. The police have an affirmative obligation upon a felony defendant's arrest to timely turn over their evidence to the prosecution. Likewise, the prosecution has an obligation to timely turn over the evidence they receive from the police or other agencies working in connection with their office to the defense to allow the defense to make effective use of that evidence. And in cases like this, where there has been some discovery turned over, it has the effect of a court order. It's the same thing as a Superior Court judge telling the prosecution, you need to turn over everything that you have, everything that the law enforcement agencies have. There was a complete and fundamental breakdown in this process during Mr. Mahatha's trial. On February 5th, 4 working days before Mr. Mahatha's trial, defense counsel received slightly over 3 hours of body-worn camera videos stemming from the evening of the offense and then Mr. Mahatha's ultimate arrest. So the times when defense counsel would have been perfecting his arguments, perfecting his cross-examination questions, he had to review 16 body-worn camera videos over 3 hours of material to review.
But unlike the Johnson case, if I'm not mistaken, he never moved for continuance, correct?
That is correct.
And even the state, well, it's not in the state's control, it's in the trial court's discretion about a continuance, but the state even offered, like, do you need a continuance, right? And he never said, I do need more time to review.
And I think you need to view, ultimately, the primary problem in this case was the almost 4 hours of recorded jail calls that came in the second day of trial. Now, I think that the court can assume that defense counsel is in the best posture to determine if the late production of evidence is going to hinder his defense. So defense counsel receives the body-worn camera videos. He received 63 photographs the day of trial, but was still able at that point in his view to move forward with Mr. Mahatha's defense. And I think that's an example of professionalism that the defendant should not necessarily be penalized for. But on the second day of trial, right before the lunch recess, when he receives almost 4 hours of recordings, at that point, that is certainly a bridge too far, especially in light of the fact that these 29 calls were between the defendant and Ms. Golden, who had already testified and had already been subject to cross-examination. And
But nothing prevented him from either recalling her or asking to reopen cross. He was able to actually ask her some questions, right?
He was able to ask her questions when she initially testified without having those phone calls to cross-examine her. And this occurred after she was allowed to testify about a 404B event that occurred in August of 2018. The large majority of the telephone calls occurred after Mr. Mahatha was arrested in that case. And you can hear expressions of love and affection. She's telling him she's going to show up at his first appearance to have the charges dismissed. She's making arrangements to bail him out of jail. There's nothing accusatory from Ms. Golden to Mr. Mahatha in that, during those calls. Now, if he would have had those calls when she initially testified, he would have been able to cross-examine her, certainly about the 404B evidence, to diminish the impact of that testimony.
Well, procedurally, we just received these exhibits were filed, I think, my docket sheet at least shows May 10th.
Yes.
You'd written in the supplemental brief that you didn't have those documents, that everybody had been trying to get them, couldn't find them. Because we had done an order last August or so asking for this. There's nothing in the supplemental brief talking about any of these, because you didn't have them at the time of the supplemental brief, obviously. But there's been no motion to supplement the brief, no motion to reopen briefing, to discuss the actual prejudice of any of these audio. You know, we've got, my count, 234 minutes of audio, only 16 of which we know anything about based on the briefing, to know what their impact may have been. And, you know, following our general principles, looking at, you know, CISC versus CISC, Judge Stillman wrote, it is not the duty of this court to peruse through the record constructing an argument for appellant. So what argument do we have in the briefing or in the arguments that any of these other tapes meant anything for impeachment, other than maybe they could be something for impeachment, maybe they could help in terms of credibility? We just don't have that in the arguments before us.
I can only assume the reason that the court ordered these 29 phone calls to be delivered and tendered to the court was to have an opportunity to review them, to hear what was said during the recordings. I spent quite a bit of time working with trial counsel to locate the recordings, and after I filed my supplemental brief was when he delivered the recordings to me. I promptly delivered them to Ms. Tackett. Now, one of the requests for relief in my supplemental brief, if the court does not feel like it's in a position to grant relief on direct review, to remand this matter to the trial court, to give the trial court an opportunity to listen to the recordings and allow a more complete record to be developed, having those recordings in hand so they can be played in front of the trial court. Now,
Before you go further, given the lack of the objection or motion, what position does that put us in as an appellate court? And as Judge Murphy said, that there's no motions or further pleadings in relation to this document, these transcripts. Where does that leave us here? I mean, this is not a second bite at the apple court. You agree with that?
yes, sir.
So are you saying there was some duty or burden on the trial court on its own motion, sua sponte, to take some action in the absence of a motion by trial counsel?
I believe the trial court should have sustained defense counsel's objection to the December 4th, 2018 phone call, and the trial court should have granted the motion to mistrial, for a mistrial that was made following Ms. Golden being recalled to the witness stand.
Did those two motions incorporate all the materials that you are claiming now are prejudicial to your client?
Yes, except
do.
at the time defense counsel was arguing specifically for a mistrial, his written motion that he filed cited 5th, 6th, 14th Amendment, constitutional principles, due process, Brady, and we have the material now, and there is impeachment-type material on those recordings. Now, one thing I would note, the Johnson opinion from the state Supreme Court dealt with approximately 3 hours of recorded phone calls that were turned over the morning of trial, 3 hours and 23 minutes, so approximately 30 fewer minutes worth of recordings than this case. The trial court denied a request for a continuance for 1 day. The Johnson court found that to be prejudicial in the context of those calls were made while the Johnson defendant was being evaluated for his mental capacity. The state wanted to challenge anticipated defense evidence that the defendant lacked specific intent. Now,
And I think it underlines your argument here that the defense there and the specialty nature of it, we would treat the same as the potential impeachment impact. It doesn't matter how particularized the Johnson analysis was, but it's all about what's relevant to the jury for consideration.
Yes, sir.
Okay.
And there's no indication in the Johnson opinion that those 23 calls were introduced into the record and the appellate courts had a chance to listen to the material in informing the court's decision. The Supreme Court in Johnson simply said, quote, the defendant did not have reasonable time to address the calls. He would have been better prepared had the motion, continuance motion, been granted. He was materially prejudiced by the denial of his motion.
But then they go on to say that notwithstanding that any, quote, the error by the trial court was harmless beyond a reasonable doubt.
Only as to the offenses that did not require a showing of specific intent. So the Johnson defendant was awarded a new trial for the armed robbery charge, which did have a specific intent component. Now,
Here, the credibility of the witness
Exactly.
goes through all of the charges.
exactly.
Yeah, excuse me, I know that it seems like most of our conversation here today is focusing on the recorded calls. Do you contend that the defendant was prejudiced by not receiving the body cam footage and the photographs in a timely manner?
I can say that there would be some prejudice based on having to review that material, as I indicated earlier, when the 3 or 4 working days before trial, the defense counsel's time is going to be spent much better reviewing witnesses, reviewing discovery that he already has. I can't point to anything in the transcript that shows a specific prejudice that is glaringly apparent from the trial record.
Either on the photos or what were the 2 items, the photos?
The photographs and the 16 body cam videos. I think defense counsel was trying to be accommodating to the district attorney's office. One thing I would note, and I think Ms. Tackett made some reference to this in her brief, the record shows that the trial prosecutor knew on December 3rd of 2018 when she interviewed Ms. Golden told her that the defendant had been calling her. Now, the defendant had been in custody since October 17th of 2018. He was being held on a federal detainer. Trial prosecutor acknowledged that as well. So the prosecutor was on notice that these conversations were taking place. The defendant was incarcerated. So the state's account that she only realized that these calls existed after Ms. Golden testified on direct are just not borne out by the record.
But didn't defendant also know that there were recorded
Yes.
calls?
Yeah. Well, yes. And one of the a policy decision that was made when we had open file discovery, and even before the open file discovery laws, their defendants had limited amounts of discovery. One of the things that defense counsel was entitled to receive was copies of all statements made by the defendant, whether they're verbal statements, recorded statements. We don't rely on defendants to tell their lawyers, this is what I think I said. The state has to turn that material over.
But this wasn't the party admission that we care about here. It's about the impeachment value of what she's saying, the other person in the conversation.
Yes. And the simple fact of 29 phone calls, they begin with a recording, this is a call from the Guilford County Jail. You have to take affirmative steps to accept the phone call. Person accepts 29 phone calls from someone they're accusing of 2 felony-level assaults at that time is, I would say, significant impeachment evidence.
Do you think that, I guess, with Johnson, is that enough to overcome, even if we gave the prejudice standard and agreed a review would be the burdens on the state to show harmless error beyond a reasonable doubt? Do you think that's enough to overcome that?
In this case, the jury returned not guilty verdicts for, I believe, 2 counts. The jury did have this case for not an insignificant amount of time. I would contend yes. Now, there's a question regarding the standard of review in this case. And I wanted to hedge my answer somewhat on what the correct standard of review is. The Supreme Court historically has said the standard of review is abuse of discretion for the denial of a mistrial motion. Now, the cases that I've cited all deal with, for the lion's share of cases where defendants have been prejudiced by evidence that shows up at the 11th hour, involve defendants that are moving for a continuance before the start of the trial. And they're arguing constitution, due process, exculpatory evidence. That gets a de novo review. And I don't think there's any question that if the prosecutor turned over all this material the day the trial started, and defense counsel said, hey, wait, we need a continuance. I haven't had a chance to review this material. There may be exculpatory evidence in the recordings. We would be here under a de novo standard. But because the state waited a day after the jury was impaneled, they're putting the defendant in a position where he likely has to overcome an abuse of discretion standard, which I think this court can find an abuse of discretion. And there's, I would direct the court's attention to the trial court dictating the basis for the denial of the mistrial motion. It's on page 338 of the transcript. The trial court indicated it considered the materiality of the subject matter, the totality of the circumstances, and the importance of the evidence. When the trial court made that statement, at best, the trial court heard one phone call that took place December 4th of 2018. The trial court did not review the other 29 recordings. So that...
Where is that clear in the transcript? I don't disagree with that. That might be a reasonable assumption, but where is that clear in the transcript, that the trial court did not review these at any point?
When they were arguing for the admissibility of the December 4th, 2018 recording, the prosecutor offered to play the recording for the trial court. My memory serves me correct, the trial court declined to listen to that recording. They had their lunch recess. Ms. Golden was, actually they had somebody from the jail that was brought over to testify. The person from the jail authenticated the recording. The recording was played. Ms. Golden testified that that was her voice and the defendant's voice on the recording. So Ms. Golden was called to testify on February 12th at 4:13 p.m., the second time. This occurred within, right before the lunch break, arguments about the admissibility of the recordings. There simply was not enough time.
It's a clear just application of math that there wouldn't have been time for
Yes.
the judge to review all of the tapes in that time period.
And the recordings were not maintained by the clerk's office as well in Guilford County. Now, the trial court said, and this is, it's on page 428. That's the section that I'm quoting the trial court. Trial court indicated that a mistrial is appropriate if, quote, serious improprieties occurred as would make it impossible to obtain a fair and impartial verdict under the law. The standard for a mistrial, and this is set out by statute, if there is a legal error or defect in the proceedings that results in substantial or irreparable prejudice to the defendant's case, then a mistrial would be appropriate. The General Assembly did not say the defendant, it would be an impossibility for the defendant to receive a fair trial. So I believe this case falls within the category of cases where the trial court was acting under a misapprehension of the subject matter, specifically all of the recordings, and a misapprehension of the applicable law. Sometimes we've seen this where a jury asks for a trial transcript of the proceedings, and there's a routine denial from the trial court. No, I can't do that. There have been several cases that have sent back because the trial court didn't understand that they did have the discretion to direct the court reporter to prepare a transcript.
Was there any anticipation in the back and forth before the trial court on how long the victim would still be testifying? If it was going to carry over into the next day, where there's an assumption that if I'm not going to do it as a statutory discovery violation, he's going to have time tonight to listen to these. Trial attorney's going to have time tonight to listen to these and prepare to continue impeaching the state's witness. Was there any estimate whatsoever that the trial court knew the state was going to recall her and how long she may remain on the stand? Was there any back and forth on the record regarding that at all?
I think the mistrial motion occurred after Ms. Golden had testified and been released. The argument regarding the admissibility of the recordings, the prosecutor winnowed down, I just want to use this one recording. I don't recall there being any suggestion that the recordings would take almost 4 hours in duration to play all of them, although there was an agreement that there were 29 recordings.
Let me ask you this, another standard, even if we found prejudice to your client, is there's other overwhelming evidence of guilt would be another basis to sustain the conviction.
Yes.
Do you want to speak to that?
Yes, sir. Ms. Golden identified the defendant as having a firearm. She would have been very successfully cross-examined had these recordings been readily available to defense counsel.
So was there evidence that there was, in fact, no weapon?
A weapon was never recovered. Now,
That's not my question.
there was her testimony that he did possess a weapon.
And there's also the officer's testimony that was not objected to. I think transcript page 226 to 228, that it appeared that the wound was from the butt of a gun. And I think it was Exhibit 16, which was offered and published to the jury without any objection or limiting instruction or illustrative purpose or anything like that. So with that coming in, even if this all would be good to impeach her testimony, we do have this officer's testimony, whether there's a proper expert foundation or whatever, there was no objection.
That is correct. He was cross-examined and I believe admitted that he had never seen what he perceived to be an injury caused by the butt of somebody's gun before.
So you feel that that was contradicted enough or impeached enough that it wouldn't be enough to be overwhelming evidence, as Judge Tyson was phrasing his question?
Yes.
Okay.
And there were 4 outside witnesses, basically roommates in an adjoining apartment that encountered Mr. Mahatha. One of the 4 said he believed he thought he saw what appeared to be the butt of a gun poking out of his waistband. He was somewhat equivocal on that. Now, I don't want to give short shrift to the. I'll answer any questions before I shift gears on this issue.
One housekeeping question: is the Exhibit 16 in any of these image file numbers? And you can answer this during rebuttal or towards the very end. Any of these file numbers actually Exhibit 16 that was used, if you're aware, the JPEGs that were filed. Sorry, I don't have the filing date on those in front of me.
All 29 recordings.
The photographs that were submitted, were any of those Exhibit 16, which was this picture that was published to the jury? Are you aware? And if not, don't spend too much time with it. Okay, thank you.
I'd have to defer to Ms. Tackett on that. If the court reviews the closing argument the defense counsel made in the McAllister case, where he acknowledges that his client, who's being prosecuted for assault and then various sex offenses, got into a struggle, I think he characterized it as a tussle with the victim, essentially acknowledged that an assault took place, and then in his closing argument he made a very impassioned plea that the jury should find the defendant not guilty of the sex offense crimes, but didn't mention anything about the assault on a female case. It is very, very similar to what we have in the case at bar. And even during Mr. Defense counsel's opening statement, he said something to the effect of, this is not going to be a case where you're going to find Mr. Mahatha not guilty of everything. And he talked about this is a case involving nuance and black and white. And then he goes on to talk about how evidence could support a finding that Mr. Mahatha did something horrible that should never happen to anybody. He tells the jury that they could potentially find the defendant guilty of assault. I'm not asking that you find him guilty of assault, but you could believe he committed a non-gun related assault. And then he goes on and on about how the jury should acquit on the gun-related offenses. So I believe that this case presents an even stronger argument for at least a remand than the McAllister case to see if Mr. Mahatha gave free
And let me ask one more question just on this. It's been presumed in a lot of literature and the writings in this state that, our Harbison admonishment, our Harbison rules, we came along early in that, and it was federalized with McCoy versus Louisiana. Do you have any different position that McCoy versus Louisiana gives any greater protection than Harbison already gave?
The last time I read McCoy versus Louisiana, it seemed to me, and I could be mistaken, I think Harbison gives greater protection.
And I think that's been the consensus. I just wanted to give you the opportunity. If you had anything else to add to that conversation, I'd be happy to hear it.
Okay.
Thank you.
I'll thank you for the court's attention, and I will defer to Ms. Tackett.
Thank you, Mr. Cassandra. From the state, Ms. Tackett, good afternoon.
Yes, Your Honor. Good afternoon.
Welcome to the court.
Thank you. Sarah Tackett here on behalf of the North Carolina Department of Justice, representing the state in this matter. There are two issues before the court today. The first is whether the trial court erred in denying defendant's motion for a mistrial, and second, whether defendant received ineffective assistance of counsel based on statements made by his trial attorney during closing arguments. As to the first issue, the state's argument is twofold. First, State v. Johnson is not applicable to this case, and the trial court did not abuse its discretion in denying defendant's motion.
Is the basis, according to your supplemental briefing, was that it was not preserved by objection? Is that the difference between Johnson and this case?
Two differences, Your Honor. As Judge Murphy pointed out, defense counsel in this case did not make a motion to continue or request additional time to review any of the evidence in this case. Specifically, the DA offered defense counsel a continuance about a week before trial when she produced the body cam footage because she recognized it was perhaps not timely. And defense counsel specifically denied needing more time to review that. Similarly, on the morning of trial when they're discussing...
So would that be invited error?
Perhaps, Your Honor. Certainly, if defense counsel believed that he didn't have adequate time to prepare and present his defense or review that material, that's something that he should have asserted at that time. He later admits during the trial that he had adequate time to review the body cam footage and the crime scene photographs, which is in part probably why he didn't ask for a continuance when the trial started. Secondly, or in addition to that, with respect to the body cam footage, the jail recorded calls, when those were produced, he didn't ask for a continuance, instead made a motion to exclude the calls, which of course was denied, and then filed his motion for a mistrial. That significantly distinguishes this case from Johnson. Mr. Costanza indicated that he was perhaps just being professional and courteous. But as a zealot advocate, if he believed that he hadn't had proper time to prepare, he should have requested additional time at that point.
Well, I don't want to open up any more issues, but are you suggesting he was ineffective?
Certainly, Your Honor, that is a consideration that's not been raised on appeal, and as Your Honors are aware, that's something that would typically be raised in a motion for appropriate relief. I think based on some of the cases, even given the issues presented and because of the lack of material evidence here, the court would determine that he had not violated his duty to provide effective assistance of counsel, but again, that's not been raised. The second issue, or the second reason why Johnson's not applicable, he's not asserted a constitutional issue in this case. In fact, he concedes in his brief that the standard is abuse of discretion. Reviewing this case for an abuse of discretion and giving the trial court's decision great deference, in particular, the consideration, or the trial court's consideration of the following factors: the lack of unfair surprise in this case. With respect to the body cam footage and the videos, as I mentioned, he didn't ask for a continuance, but he also specifically indicated to the court that he had no discovery-related objections to that evidence. And our case law is clear that when you don't raise any potential unfair surprise at the trial court level, you cannot later claim that you were unfairly prejudiced by the production of that evidence. With respect to the jail-recorded calls, the prosecutor explained on numerous occasions that she had spoken with the victim witness. She understood that the defendant had been calling her, but she didn't know until trial that those calls were being made after the defendant had been arrested while he was sitting in the Guilford County Jail.
But that only goes to what the appropriate sanction would be, correct? Not whether the discovery statute has been violated.
Certainly, Your Honor. That is an important distinction, and in the trial court's discretion, based on the circumstances presented, did not find that the trial court that the state had violated its duty.
How do you respond to your friend's position, kind of two parts when it comes to abuse of discretion? One is kind of misapprehension of what the subject matter was. You know, I think the math may hold out that the trial court wouldn't have had an opportunity to review those, even if the record is silent. I think the math of the record may make that clear on its face. So I ask you to respond to that. And then also, you know, misapprehension of the applicable law and the proper standard for mistrial that was expressed on the record. You know, those are two things that, you know, we don't find abuse of discretion very often, but those are the two things. If the trial court wasn't looking at the right thing or thought the law was different than it was.
The transcript, I disagree with that. I disagree with that in the sense that the transcript on page 428 does indicate that the court properly considered and applied the standard of review, specifically indicating that mistrials are only appropriate when such serious improprieties have occurred or the defendant has been substantially or irreparably prejudiced.
Was the burden on trial counsel at that time to say why he was burdened and prejudiced by not being able to impeach, or what else he would have used to try to convince the trial court why the trial's gone so off kilter? Is that something that needed to be raised there at the trial level, or can that wait till here to look at everything in its entirety?
Sure. Certainly that would have helped convince the trial court that his client had been prejudiced, and that's something that would have given the trial court perhaps more circumstances to consider in granting that. At this point, certainly he can assert that he was prejudiced, and it's this court's job to determine whether that was the case. But in giving the trial court's decision great deference, the circumstances of this case do not indicate that there was an abuse of discretion, not only because of the unfair surprise, but because of the specifically what the trial court considered, the lack of bad faith, the materiality of the evidence, and then based on the totality of the circumstances.
Have we ever held, you know, we often hold that you can't swap horses on the basis of your legal argument or the way you're phrasing things. But have we ever held that you didn't do good enough really laying out what the prejudice problem was, that you can't, at the appellate level, say what the prejudice problem was and ask us to look at that anew? Has that,
not to my knowledge,
that part of it ever come up? Okay.
Not to my knowledge, Your Honor, no. Significantly, even if the disclosure of the evidence in this case was untimely, giving the trial court's decision great deference, this court should determine that the trial court didn't abuse its discretion. But even if this court determines that, the defendant cannot show that he was materially prejudiced by the disclosure or by the denial of his motion. As this court held in State v. Ramsher, to obtain relief on the basis of the state's discovery violations, whether they are properly characterized as statutory, constitutional, or both, defendant must demonstrate prejudice, that there exists a probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Unlike in Johnson, in which our Supreme Court determined that not having the calls there sufficiently prevented his attorney from meaningfully addressing that evidence, not only during his closing argument, but in consulting with his expert witness, which ultimately could have impacted the jury's decision, defendant here cannot show that having the calls prior to trial would have changed the outcome in this case. Quoting, I'm sorry?
Sorry, no, go ahead and finish that, sorry.
Quoting from defense counsel's closing argument at trial, which is on page 395 of the transcript, they, in reference to the court, could have played 28 other jail phone calls for you. They didn't. That's the best they got. One phone call where he doesn't admit to a crime. By defense counsel's own words, the December 4th call introduced by the state was not material to this case. I'm sorry, did you have a question?
Yes, in looking at what our prejudice level is, if we find that there was a discovery violation, and we just determined that was a discovery violation both under the statute and under Brady, if we determine it under Brady, doesn't that push the burden onto you as the state to say why that's harmless beyond a reasonable doubt? Or is there some other standard that we apply if we decide that not only was it a statutory violation, it was a Brady violation?
Certainly, Your Honor, if the court determines that there was a Brady violation, the burden is on the state to prove harmless error. In that context, the court would be looking at the effect of the disclosure on the outcome of the trial and not on the defense attorney's ability to prepare and present his defense. But in this case, not only has defendant not asserted that there was a Brady violation, the evidence was not favorable to the defendant, and it was not material. So there couldn't have been a Brady violation.
And that constitutional error would need to have been raised at the trial court before you bring it here, correct?
Absolutely, Your Honor.
And it was not?
No, it was not, Your Honor.
So the state's position is that the motion for mistrial was not all-encompassing of due process, which would include Brady.
As Mr. Costanza indicated, the written motion for a mistrial did reference the defendant's constitutional issues, both federal and state, specifically the 5th, 6th, and 14th, I believe. However, during the oral argument or the hearing on the motion, defense counsel does not reference those constitutional issues. Instead, he indicates to the court that he's making his motion pursuant to General Statute 15A-1061 and 15A-910.
But if he files it,
Yes, Your
isn't that enough to put that issue before the court? There's not any case law that says if you file a motion and you actually only are heard on a couple parts of it, that's
Sure,
the end
Your
of
Honor.
it, correct? I mean, the Supreme Court's kind of been going the other way with Golden and things like that with general motions to dismiss.
Absolutely, Your Honor.
Okay, I just want to make sure I'm
No, the state
understanding the parameter there.
didn't find a case to that effect either. I would note that the trial court didn't actually make a ruling on whether the defendant's constitutional issues or constitutional rights were violated, but certainly he's not prevented from, this court's not prevented from determining that, even though it wasn't raised on appeal. The state would contend that even if this court determines that there was a constitutional violation, the defendant still can't prove that he was either prejudiced or if prejudice is presumed that there was that the error wasn't harmless.
In terms of appellate procedure, I'm looking at, I was unfortunately out of town last week, so when I returned, I've got almost 4 hours of audio tapes that my clerk has started going through, but I haven't started going through yet. What is our review at this point of these other tapes based on the briefing? What is the state's position? I know what I think my position is, but I want to know what the state's position is.
Well, Your Honor, the calls were included, all of the calls were included as an exhibit at trial, not just the one that was played for the jury. So certainly it is, while it wasn't included on the record on appeal because they couldn't be obtained until just a few weeks ago. Certainly, they are a part of the trial. They were admitted at trial and can be considered, but as you mentioned, they were not, the substance of those calls were not specifically addressed, again, because Mr. Costanza didn't have them to address, I understand. But at this point, I think, especially given the court's order requiring those calls to be produced, looking into or considering the nature of the calls itself is appropriate. And in doing
But what would our review be? I mean, we're not going to do an Anders review where we're playing defense attorney and trying to make up prejudice arguments of how this, 7-minute call could have been useful for impeachment of this other thing she said. I mean, we can't play that game.
No, Your Honor. I think the review would be simply to determine whether there was, as Mr. Costanza asserted, any impeachment value with respect to Ms. Golden. That was ultimately the point of his supplemental brief. And the state contends that is not the case for a few reasons, specifically that the calls would not have been useful in impeaching her credibility now that we have them and can listen to them, for 2 reasons. First, the timing of the calls. Only 4 of the 29 calls took place after the assault at issue in this case, which occurred on October 14th, 2018. One of those 4 calls was the call that was ultimately played for the jury. One of them was a call by another inmate calling Ms. Golden on the defendant's behalf. So really only 2 calls took place after the assault at issue here. The other 25 calls occurred in September or May 2018 when the defendant was in jail and previous charges for allegedly stealing Ms. Golden's cell phone in a prior assault. As she testified at trial, she and the defendant had reconciled at that point. She was actually trying to get him out of jail, post his bond. And so it's not surprising that there were so many conversations between the 2, despite defendant's assertions.
So are we really looking at 4 and not 20?
Yes, Your Honor. In terms of potential relevant
As it relates to
impeachment.
these charges?
Exactly, Your Honor.
Today.
Exactly.
Well, did the defense counsel know that?
He certainly had included with the calls is an Excel data sheet that lists out.
Dates and times?
I'm sorry?
Dates and times?
Exactly. Dates, times, length of call, and actually the inmate number the corresponding inmate number. So there's a few that you can tell aren't from.
Just from my recollection, what page is that on the record? Where? Or approximately?
I am not sure, Your Honor. I apologize.
Isn't it pretty much standard, Mr. Costanza references there's a recording when a call is made from the jail that this is a call originating from the jail and blah, blah, blah. Isn't it also posted at the jail that the calls are being recorded?
That's my understanding, Your Honor. And having listened to all of the calls, it's quite obvious for at least 2 minutes of every call that this call is recorded, and every party's aware of that. And in several of the calls, the defendant makes reference to that by saying, I don't want to talk about this on this call.
So he was obviously aware that the calls were being recorded.
Very much so, Your Honor.
But defense counsel was also aware, given the voluntary discovery and the motions and, voluntary participation, that if there were calls, the state was supposed to be handing them over.
Sure, Your Honor. I think the difference is that the state wasn't even aware that there were calls.
But the district attorney's office was not aware.
Sorry.
And I think that's one of the problems that slips in sometimes with the language in
Sure.
these opinions is when we're here talking about duty to disclose, we're talking about the state being the state of North Carolina generally, correct? Not just the district attorney's office.
Right, exactly, Your Honor, yeah.
Would there be a duty to disclose telephone calls that predated the offense?
Certainly, depending. So if there had been a discovery request or an order of the court compelling discovery.
Sure, I understand that,
certainly.
but I mean, under the open file discovery, maybe the state wouldn't even know there'd been calls. This could have been a year or 2 earlier.
Sure, and
There
I
could
think,
be a big time separation between the current charges and any phone calls and calls that occurred months or even years earlier.
exactly, and I think that is the case here. Significantly, most of the calls were not, now they happen similarly or close in time. I think there's about 6 weeks between the 2 assaults. when he goes back to jail. But exactly, and then even with respect to the calls that happen after this assault, when the DA talked with the victim, she wasn't told that those conversations had been recorded between the defendant. And actually, the one call that was played for the jury didn't take place until the next day. So she spoke with the victim on December 3rd, 2018, and the call that was played was actually from December 4th, 2018.
So going back to our standard of review, in the absence of an objection or motion to continue, we've heard that it's abuse of discretion. We've heard that it's harmless beyond a reasonable doubt. We've heard prejudicial. I mean, where are we?
I think starting at the very beginning, I think the court should apply the abuse of discretion standard, determine that the trial court did not abuse its discretion in either.
And that's on the denial of the mistrial?
Yes, Your Honor. It wasn't specifically raised on appeal, the question of whether the state violated its duty to disclose, but I think in implicit or as a foundational piece of that, the decision to not grant the mistrial, that certainly is a piece of that. But at the base, the standard of review is abuse of discretion. And only if the court determines that the trial court abused its discretion do we move to looking at whether the defendant was materially prejudiced or whether there was any error, harmless error.
If the constitutional issue was raised and preserved, which would do a harmless beyond a reasonable doubt standard, do we still sustain the convictions?
Yes, Your Honor.
Even under that burden?
Even under that burden, yes, Your Honor. The state introduced significant, I think your words, overwhelming evidence of his guilt, including testimony from the victim herself that the defendant had assaulted her, numerous crime scene photographs depicting her injuries, as well as the blood all over the apartment from the attack that night, but also testimony from 4 unbiased witnesses placing the defendant at the scene of the crime immediately after it happened, where he admits that he had just gotten into an argument with his girlfriend. In addition to that, testimony specifically about whether he had a gun that night. You had Ms. Golden's testimony that he always carried this with her. You had one of the witnesses' testimony that he believed he saw a gun in the defendant's pocket when he was getting in the car, and that's why he jumped out and ran to go call 911 in the first place. You also had the officer's testimony that in his opinion, the injury to Ms. Golden's face was consistent with the butt of a gun. Considering all of that evidence, in light of the ample evidence of the defendant's guilt, any error in the trial court's decision was harmless beyond a reasonable doubt. Just want to go back to the nature of the substance of the calls themselves.
Let me ask a question real quick.
Sure.
It's more related to what Judge Tyson's getting is, let's assume for a minute, we come to a resolution that says, okay, there was enough prejudice on assault of a female and communicating threats, but there was on the deadly weapon part of serious injury, and there was on possession of a firearm by a felon. And the reason I ask is because I think this gets very confusing for the trial courts, and if something goes back for remand for a new trial, is if we set aside the assault with a deadly weapon with serious injury, which is consolidated with the assault on a female and the communicating threats, and also the possession of a firearm by a felon, what is the status, given that he's already would have served his time on the assault on the female and communicating threats, of his incarceration status pending trial? And I asked because the case of State versus Loftus came down, and it was a mess when I was appointed as trial counsel for the second trial. We didn't know if he was still supposed to be in custody or not.
Sure.
So does the state have any thoughts on that potential logistics aspect if part of this, the biggest part of this judgment is set aside?
Set aside,
Set aside meaning new trial.
Right.
On a bigger part.
Sure, and should the state decide to retry him,
Yes.
first I would assert that he would be convicted again. But specifically with respect to the sentencing, that would make a difference because they were consolidated. The assault with the deadly weapon and the felon in possession of a firearm. Yes, Your Honor, I would agree with that.
With the possession, let me make sure I'm right here. The possession of the firearm is under a separate judgment,
It's a separate one.
and it's a consecutive sentence. Is that not correct?
Yes, Your Honor.
So basically, he would have to have exhausted, and I realize he had substantial pretrial detention, over a year.
Sorry, say that again?
He had substantial pretrial detention,
He did. He was,
over
yes,
a year,
he was.
over 400 days.
He was in federal custody.
Right.
yes.
So, I mean, the sentence on the sentence on the possession of the firearm would not even accrue until the expiration of the first one. He'd have to serve that in its entirety, correct?
That's my understanding, yes, Your Honor.
So, I don't know, if you go to the substantial evidence to support the conviction of firearm by the felon, based on the testimony of the mark and the victim's testimony and the eyewitness testimony, would there be any basis to overturn that separate conviction, even as it related to the phone calls or anything else?
No, Your Honor, there was no discussion within any of the calls regarding whether he had a gun. The only piece of that was the one call that was actually played for the jury, where defense counsel makes a point to say, he specifically says, I wasn't found with no gun. But that's the only reference to a gun at all in any of those calls.
And that was played for the jury, and that was subject to, complete challenge, correct?
Exactly, absolutely, and complete recross-examination of Ms. Golden about that.
You have about 5-6 minutes left.
Thank you, Your Honor. With that, I'm going to turn to just quickly to the second issue.
Is this the IEC?
Yes, Your Honor.
Don't we generally just let that go back without prejudice for a mar?
Certainly, Your Honor. In this case, though, I don't think that would be necessary, given that everything the court would need to make its decision is included in the record, especially now that we have the jail recorded calls.
Okay, so basically, you think the record's sufficient for the court to make a decision?
Exactly. Quoting our Supreme Court in State v. McAllister, a finding of harbison error based on an implied concession of guilt should be a rare occurrence and only occurs when defense counsel's statements to the jury cannot logically be interpreted as anything other than implied concession of guilt to a charged offense. Despite defendant's assertions, none of the unique circumstances presented in McAllister are present here. For one, the defendant never admitted that he assaulted the victim, and no statements were made by defense counsel during closing arguments attesting to the state's evidence proving otherwise or bolstering any of the testimony from Ms. Golden or the other witnesses. Second, counsel here never indicated that he personally believed that the defendant had in fact committed an assault, nor did he tell the jury that they should believe what Ms. Golden claimed happened. Instead, his statements were posed as a hypothetical. Specifically, on page 384 of the transcript, he says, "This is a case where you may find that he did something terrible. No one deserves to have what may or may not have happened to Ms. Golden. And nobody's going to stand up here to tell you that it's okay or that any of that behavior, if true, is okay." This was counsel's way of saying, look, jury, if you believe the evidence from the state, if you believe what Ms. Golden is saying happened to her, everyone agrees that's not okay. But he specifically phrased it in a way that implied it was possible that what she was saying was not true, that it may not have happened as she described, which was entirely in line with defense counsel's efforts throughout trial and very much so in his closing argument to undermine Ms. Golden's credibility and convince the jury that she wasn't telling the truth, either on the stand when she testified or when she spoke with the 4 witnesses that night. Finally, unlike in McAllister, defense counsel here did specifically address the assault on a female charge twice, although not as emphatically as he addressed the other charges. But specifically on page 387 of the transcript, he states, "You can believe that he committed an assault. I'm not asking you to find him guilty of assault on a female, but you can believe he committed a non-gun related assault. He goes on, and right towards the end of his argument on page 405, he says, "You have assault on a female. I'm not asking you to find him guilty of that. Do what you believe the law requires you to do." Again, this was after spending significant time questioning Ms. Golden's credibility, pointing out the inconsistencies in her testimony, and also explaining to the jury that the burden was on the state to prove beyond a reasonable doubt its case. So at this point, when he says, "Do what you believe the law requires," he's telling the jury, consider the evidence, consider the law, and urging them to use their discretion and determine whether the state had met its burden, which is a far cry from counsel's statements in McAllister, where he says, "God knows he did," referencing did wrong. These statements are much more in line with defense counsel's statements in State v. Green. In that case, defendant was charged with first-degree murder for slapping a child. Defense counsel told the jury it could find that the slap was negligent. It could find it was reckless disregard, but that he wasn't telling them that they should find that. Finding no harbison error, our Supreme Court held that counsel's statements or counsel's argument was simply that defendant was innocent of all of the charges, but if he were to be found guilty of any, it should be involuntary manslaughter and not murder. That's exactly what defense counsel was trying to do here. He specifically told—
Is that basically arguing for an alternative or arguing for a lesser included?
In essence, yes. Assault on a female is not a lesser included charge of assault with a deadly weapon inflicting serious bodily injury, but both charges do require the state to prove that the defendant intentionally assaulted the victim. So the logic of the analysis is that the analogy is there. And in this case, defense counsel was telling the jury, if you believe the state's evidence, again, not telling them that they should believe it, but if they did, at the very most, they could believe that he committed an assault, but that the evidence specifically as to whether he had a gun was not credible, and therefore, at most, they should determine that the state hadn't met its burden as to the more serious gun charges. Furthermore, despite counsel's best efforts, the jury did convict defendant of assault with a deadly weapon inflicting serious injury. And this was based on the significant evidence at trial, which I've already somewhat laid out, Ms. Golden's own testimony that it happened, the photographs corroborating her injuries, and then the testimony of the 4 witnesses who found her bleeding in a parking lot that night, and who saw the defendant when he admitted they'd gotten into a fight. So they convicted him based on the evidence, not based on what defense counsel said or didn't say during closing.
I'll give you a moment to sum up.
Let me ask one question, just procedurally, real quick. I'm looking through the record I've got printed here, and I don't see the actual discovery request. All I see is the statement on record, page 16, paragraph 2, in the motion for mistrial. Does the state agree and or stipulate that this is accurate, that the defendant did make these pretrial requests?
He did, Your Honor. The transcript
Okay.
does reflect that request was made.
Thank you.
In summary, the defendant's constitutional rights were not violated, and this court should dismiss the defendant's appeal as to this issue. In the alternative, the court should remand the case for an evidentiary hearing to determine whether defendant consented to the implicit concession of the assault on a female charge.
And as to the IAC,
I'm sorry?
as to the ineffective assistance,
Yes.
you would have us to decide the case on the record before us?
Yes, Your Honor.
And not dismiss it without prejudice to Amar. Is that correct?
Exactly. Correct, Your Honor.
Thank you.
Thank you, Your Honors.
Mr. Costanza, I think you have about 4 minutes left.
And Judge Tyson, to the extent we raised an IAC claim, it's specific as to the Harbison concession issue. Judge Tyson, you brought up a question.
Real quick, so just to be perfectly clear, just my interpretation is we don't even need to get to Strickland. We're only doing Harbison.
Yes.
Thank you.
Judge Tyson, you asked a question about should recordings be turned over of jail phone calls that occurred before the crime at issue. The defendant in this case was being prosecuted for common law robbery involving an August 24th, 18 allegation that he robbed Ms. Golden of her cell phone. Same prosecutor that was prosecuting that case prosecuted this case. And I believe 24 of the recordings occurred after that August 24th arrest, where she's talking about bonding him out of jail and how much she loves him and how this was all just one great big misunderstanding. And the state was able to use Ms. Golden's testimony about that August 24th incident. He beat me, he choked me, he wanted my cell phone, to set up the argument that it was just like what happened October 7th.
So it's used to show a pattern, is
Yes.
what you're trying to say.
Yes, sir.
You know, my question was more theoretical than that. You know, if there were phone calls separated by months on unrelated, I mean, would there be a violation for the state not to disclose those when they're related to something wholly different than the issue before us?
I cannot with a straight face say that that would be a violation. There are people that cycle in and out of jails, and there's recordings that go back years of the same individual. That's not what we have.
It'd be an almost impossible administrative burden to try to
Yes, sir.
reconstruct and pin those specific calls to a specific.
But in this case, we have calls referencing an event that the state wanted to use in the trial to implicate.
You said that the totality of everything was about a 6-week period, involved the same parties, same victim.
August 24th to October 18th of 2018.
And to be clear, is your position that all of the phone calls fall under this paragraph 2 of any exculpatory evidence or statements that would tend to weaken the credibility of a state witness, regardless of if they occurred before or after?
Yes, and under 15A903, the general catch-all, everything that the state, the police recovers entitled, or defense counsel is entitled to. Judge Zachary, I think you made you had a question about our contention regarding the body-worn camera video and the photographs. I am not contending that a mistrial should have been granted based on the late disclosure of that material. Defense counsel received it late, but he was able, and he was in a position to I think, credibly say, I can still go forward with Mr. Mahatha's defense. But I think that adds credibility to his contention when he gets, you know, these recordings the second day of trial, that he is not in a position to make that same concession. I hate to fall back on overused metaphors, but straws breaking camels' backs, that's what comes to mind.
Do you contend the state acted in bad faith by failing to comply with the discovery?
I'm sorry, Your Honor.
Do you contend that the state acted in bad faith?
They were grossly negligent. When their witness tells them he's calling me from the jail December 3rd of 2018, and over a year goes past before they make any effort to track down these recordings. Ms. Tackett said that Mr. Mahatha nor I asserted a Brady violation occurred. And what I can tell the court is when the trial took place, trial counsel, defense counsel, was not aware of exculpatory evidence being in existence and being withheld. But he clearly cited in his motion for a mistrial the potential of a Brady violation. He even cited Brady in his motion. The briefs that I filed cite two cases dealing with effective assistance of counsel. I talk about the difficulty of appointed counsel being able to give effective assistance of counsel when they're receiving evidence at a very late hour. And I cited the Kennedy case from the North Carolina Supreme Court, which is one of our leading state Supreme Court decisions interpreting Brady. And Kennedy has language in it that Brady disclosure is timely if the material is given in an amount of time to defense counsel for the defense to make effective use of the material. So trial counsel, myself, we identified a potential Brady claim, and with the recordings finally being produced, it is replete with impeachment evidence. Impeachment evidence is Brady evidence. This court has a defendant in front of it who did not have a constitutionally mandated disclosure before he went to trial for some very significant
But do we
offenses.
have, I think this goes back, you referenced Brady's reference below, due process is mentioned. Do we actually have a Brady argument in front of us to decide based on what's in the briefs, not taking our own view of what impeachment value may be in those phone records.
You have,
We have a Brady framework.
yes.
And Brady's referenced here. But is this, because even your header doesn't mention Constitution, it says abuse of discretion. Is this actually a Brady argument in this brief for us to have before us to properly decide in the adversarial process?
The constitutional argument that I made to this court is that that defense counsel was not able to effectively represent his client based on the late disclosure, noting the potential for a Brady violation. I was not in a position to say that there was material that was withheld, that was exculpatory to the defendant, because I didn't get that until about a month ago.
But within that month, there's never been a motion filed to reopen the briefing here, right?
No,
Okay. I just want to make sure I'm not trying to be accusatory, I'm just making sure I haven't missed anything in the docket sheet.
And again, I think the court has as a potential remedy what I set out in the supplemental brief when I was pulling what's left of my hair out to get these recordings, remand the case to the trial court, defense counsel will have subpoena power. I think just in the interest of judicial economy, you have the recordings. And
What would you have us do?
I would have the court listen to the recordings. There's no dispute at this point that these were the recordings that were made that were turned over the second day of trial. And if you find that exculpatory and/or impeachment evidence was on those recordings, then you need to review the convictions in light of that evidence and determine if the court still has confidence in the verdicts that were handed down. We don't have to show that it was more likely than not that a jury would have found Mr. Mahatha not guilty. The court just has to feel that the confidence in the convictions were undermined to award a new trial.
Thank you.
I'll entertain any other questions.
Do you have any other? Thank you.
Thank you so much.
Thank you. Thank you both for your arguments. That concludes our docket today. Ms. Soar, will you adjourn court?
Yes, sir. All rise. This session of the North Carolina Court of Appeals is adjourned.